Hi, this is John Linneball from John Linneball Tutoring, and this is Advanced Placement U.S. History, Video 27, Federalism versus Anti-Federalism and the Bill of Rights. And please, if you like this video, don't forget to comment, like, share, and subscribe. Federalism. Constitution supporters named themselves Federalists. Alexander Hamilton, John Jay, and James Madison were important Federalist thinkers. As the New York City Constitutional Convention was proceeding in late 1787 and 1788, they jointly wrote a series of articles which would later be published in a book called The Federalist. This important book illustrated the failures of the Articles of Confederation and touted the benefits of a powerful federal government. So here we can see the cover page to the Federalist, or rather the title page. Anyway. Federalism continued. In Federalist number 10, Madison argued that a complex government was the best way to guarantee liberty to the diverse members of the large population. The idea was a complex government couldn't be taken over by one group that could then oppress other groups. This is the exact opposite of the small r Republican idea that small local government is the key to holding government responsible to the people in a republic. So I don't mean Democratic versus Republican like today, but Republican as in a republic versus some other kind of democratic representation. And here we see the checks and balances. So the executive, he can veto bills, recommend legislation, call special sessions to influence the legislature. He can appoint judges, can grant reprieves and pardons. But the judiciary can rule that a presidential action is unconstitutional. Legislative can impeach the president and remove him from office, such as what's going on with Donald J. Trump as I'm recording this. And vice versa. The legislature can refuse judicial appointments, can impeach judges, can create lower courts. So all of these people can affect each other. So anyway, in Federalist number 51, Madison argued that the separation of powers was the key to preventing runaway power in the hands of one individual or small group, stating that ambition must be made to counteract ambition. So ambitious people in the legislature might be blocked by the president, or they might be blocked by ambitious people on the Supreme Court. Anti-Federalism. Despite their name, the Anti-Federalists, they weren't just stubborn, like, no, I don't like federalism, that's stupid. They actually had some really valid points. In fact, they had some very valid points, as we'll see in a minute. The opponents to the Constitution, called the Anti-Federalists, were concerned that the elite would control the new government, since the Constitution appeared to lean towards the creation of a powerful elite ruling class. Patrick Henry, remember him from the Revolution, George Mason, and Samuel Adams were some of the main Anti-Federalists involved with the Constitutional Congress, or Constitutional Convention, I should say, anyway, who asserted the Republican idea that a national government would practically by definition be too distant to be controlled by the common citizen. Now, since the colonies had just rebelled against a powerful distant government, that being Britain, they didn't want to create a new one. So the objections of the Anti-Federalists that the Constitution failed to protect individual rights led to the creation of the Bill of Rights. So the Federalists are saying, okay, fine, we'll give you a Bill of Rights. Okay, are you happy now? So that's what's going on at the Constitutional Convention. The ratification of the Constitution. Delaware, you might have seen on a Delaware license plate, they're the first state, ratified the Constitution very quickly in December 1787. Four more states, Pennsylvania, New Jersey, Georgia, and Connecticut, followed in January 1788. Massachusetts political leaders, including Samuel Adams and Governor John Hancock, and some activists from Massachusetts who were followers of Daniel Shays, remember Shays' rebellion, were present and opposed the Constitution. Federalist leaders promised a Bill of Rights to appease the Anti-Federalists. In February 1788, Massachusetts signed on to the Constitution, and in May of 1788, Maryland and South Carolina ratified it. New Hampshire passed the 9th and deciding vote, which meant it was going to be ratified. They only needed a majority of the colonies. Well, they needed 9 out of 13, which is more than a majority. But anyway, they needed 9 out of 13 to make this thing go. So New Hampshire passed the 9th and deciding vote by June of 1788. Virginia and New York signed on in 1788, North Carolina signed on in 1789, and Rhode Island signed on in 1790.
Did you know that you have rights? The Constitution says you do, and so do I. I believe that until proven guilty, every man, woman, and child in this country is innocent.
The Bill of Rights. As our friend Saul has told us, yes, it's true. You have rights as a result of the Bill of Rights, the first 10 amendments to the Constitution. These were passed to get those opposed to excessive central government power, that is, the Anti-Federalists, to agree to the new Constitution so it could be ratified and put into effect. The first 8 amendments are basic personal rights, including the criminal procedural rights, to protect citizens from a heavy-handed law enforcement, so we don't have a police state in this country. The 9th and 10th Amendments were catch-alls for rights not mentioned in the Constitution. The default is people have rights, not the government. So the idea is people have rights that they can give to the government, not that the government decides what rights people get. That rights reserved for governments must be specifically reserved, and any right not specifically given to the federal government or the states is reserved for the people. All right, so let's look at the 1st through 4th Amendment. These are just basic personal rights. Some of them also relate to criminal procedure. So, freedom of press, freedom of speech, freedom of religion, freedom to assemble peaceably, these are all in the First Amendment. You've probably heard of that before. So, the First Amendment is freedom of speech. The idea is if there's an opinion you really, really dislike, guess what? That person has a right to express his or her or non-binary pronoun opinion as much as he, she, they, it, whatever want to, including an it like a corporation. A corporation can express it. So, here are some free speech protesters here. So the First Amendment is freedom of speech. The text of the First Amendment is, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. So what does that mean regarding speech, press, etc.? Speech in the press cannot be censored by the government except in very narrow circumstances. Think wartime. You can't say, oh, guess what? The Marines are going to be landing on this beach in a foreign country at about 6 o'clock tomorrow morning. Oh, that's local time too, because obviously that would alert enemies. And there's some other things that are just very nasty. You can't publish child pornography. You can't, the classic example, you don't have a constitutional right to yell fire in a crowded movie house. Anyway, it's also subject to time, place, and manner restrictions. Can't have an all-night Metallica concert from 12 to 7 a.m. or something like that in a residential neighborhood. It's not going to happen. Anyway, but radio and TV can be censored, the FCC.
The FCC, the Federal Communications Commission, decided all by itself that radio and television were the only 2 parts of American life not protected by the free speech provisions of the First Amendment to the Constitution. I'd like to repeat that because it sounds vaguely important.
In case you're wondering why they found that radio and television were 2 things that are not covered by the First Amendment, the main reason is because broadcast television and radio are things that are literally pervasive. That is, the radio waves and TV waves actually reach into your house. All you have to do is turn on your TV and turn on your radio. Whereas even something like cable television, you had to subscribe to cable, so that involves a choice. That's basically why the FCC decided that free speech guarantees of the U.S. Constitution don't apply to the 7 dirty words you can't say on television. You can look that up on YouTube. It's a very funny routine from the early 1970s, I believe 1971 or 1972, which I am not going to repeat here or post here because they are naughty words and I'm not going to be responsible if you are offended by them. Private publishers, newspapers, websites, etc. are not restrained by the First Amendment. What I mean by that is you won't win a lawsuit against your local paper if you try to sue them because they didn't publish your letter to the editor. First Amendment continued. Freedom of religion. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The text of the First Amendment is that Congress shall not establish any religion. While this is usually interpreted as separation of church and state, I'm sure you've heard that, some people do argue that all it means is Congress can't start an official religion for the United States. Now, that interpretation has mostly been rejected by the courts because, well, it's silly. Basically, the U.S. Supreme Court has always interpreted that as the government's favoring any religion over another is an establishment of one religion as an official religion. And if it just did it with one religion, it'd be the official religion. So if a religion is the official religion, then we have something like America is a Christian nation. Probably have heard that before. It's not true. Also, a possible scenario where the U.S. has more than one official religion could say, well, the government really only recognizes Roman Catholic and Jewish holidays. If your religion has different holidays, that's too bad for you. So that would be favoring one religion over another. Probably unconstitutional. Certainly would be something you might want to sue over. It's not legal advice. I don't have a bar license in any state that's valid, so please, if you need legal advice, go talk to someone who is licensed in your jurisdiction and don't take the advice from commentary on a YouTube video. But anyway, so freedom of religion is also freedom from religion. That is, atheists have First Amendment religious rights, and freedom of religion means all religions, not just your own. Second Amendment, gun rights. This is a very controversial amendment to the U.S. Constitution. The text of the Second Amendment is, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. You've probably heard of the right of bear arms, and sometimes in cartoons they show somebody's got some bear arms mounted on a wall. That's what it means, you have a right to have bear arms. Ha ha ha. What about the right to arm bears? Okay, stupid jokes aside, it's controversial because we don't know what constitutes a militia. Is the National Guard a militia? Yes, I would say so. Is any group who say they're a militia automatically a militia? Well, that's a problem. Maybe, maybe not. Courts do generally interpret this as anyone who has the right to own guns, at least for home defense, hunting, etc. So you could probably form your own militia, but you might run into problems if you don't go and get a gun license that you might need in your state and just decide to carry arms because I'm a free citizen and I have a right as a militia. Don't count on it. Anyway, there are definitely laws that place limits on what kind of guns people can own, how they can use them, etc. And so far they haven't been stricken down under the Second Amendment, so there are some limits on your Second Amendment rights. So organizations that favor a loose interpretation that say, hey, you should be able to carry any kind of gun you want at any time with you because you have a right under the Second Amendment. Everybody can be a militia if they want to. That would be the National Rifle Association, the NRA, or the GOA, the Gun Owners of America. Strict interpretation would be organizations like Everytown for Gun Safety, Brady PAC, started by Brady, who was shot in the head when Ronald Reagan, when they tried to assassinate Ronald Reagan. John Hinckley managed to hit Brady in the head, so his wife basically started that group. I think. I don't know. Correct me if I'm wrong. Basically, somebody in Brady's family. I'm not sure Brady himself is in a situation to be starting any lobbying groups. Anyway, Third Amendment. Oddly specific. Here's the text. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. So if you're wondering why this oddly specific thing is in the Constitution, remember, during and before the Revolutionary War, the British required colonists to house troops as needed. They didn't want to pay that much. They thought the colonists, hey, we did you a favor by helping you win against the French and the Indians, so you owe us, let us stay in whatever boarding houses you have or spare rooms in your house, etc. So, needless to say, although I'm saying it, is people felt that was a pretty huge imposition and it wasn't fair. So they felt it was important enough that they actually put it in the Constitution. There was an old TV sketch, I don't remember whether it was Saturday Night Live or Living Color or Mad TV or whatever, but shows troops walking into the modern, 20th century, so, late 1900s, like 1990s home. Well, the army base is full. Then the owner pulls out his copy of the Bill of Rights and said, it says here in the Third Amendment, okay, so, all the troops march out of the house. We're like, geez, we're defeated by the Third Amendment again. Anyway, Fourth Amendment, search and seizure. So the Fourth Amendment says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized.
This is my own private domicile, and I will not be harassed, bitch!
So you can't just go around searching people randomly if you're the police, and you have to have a specific enough search warrant supported by some credible oath from somebody who can be believed or is credible. So can't be, I want to go search everything associated with Joe Schmo, including Joe Schmo himself, and because I have reason to believe that he's got drugs. You'd have to say, okay, this person, Saul Stool Pigeon, saw him sell drugs to somebody else, and blah, 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 blah. We found a glassine bag that's consistent with drug dealing with Joe Schmo's fingerprint on it. And anyway, so what that means for you. The Fourth Amendment shows there is an implied right to privacy and protection from police overreach in the Constitution. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, that really wouldn't mean anything unless there's an implied right to privacy. So, no searches and seizures without warrants issued upon sworn testimony, particular description. That's why the police can't just stop you on the street, search you or your car, or go on what attorneys like to call a fishing expedition where, hey, we're just going to tear through everything. They also can't just stop you randomly either if you're walking down the street, or stop your car and say, well, you know what, we've decided to search your car, we've decided to search you. Why? Because we felt like it. There are some exceptions. They can set up a DUI roadblock if drunk driving's a problem, like on New Year's Eve, where they just stop every car, or they stop every third car or something. As long as it's something that's random, they can do that. Of course, they can do it if they have some sort of probable cause. If they see you driving your car, weaving back and forth, you obviously are not driving well. They can say, all right, maybe this guy's drunk. Hey, maybe he's got a medical problem and he needs help and we need to help him out. So it can also be consent. If you tell the police, yes, officer, why, I would love to have you search my pockets. Hey, you want to come to my house and search my house too? Well, can't object later if they find contraband on you and you get arrested. Search after arrest. Same thing. They can search you after an arrest because once you're in their custody, what if you said, hey, I had $5,000 in my wallet, and then when they let me go, it wasn't there? And they'll say, no, we did an inventory. You had $5 and, a few mints and things like that. You didn't have you didn't have $5,000. And plain view, if the cops see you carrying a huge bag of drugs down the street where anybody could see that they're drugs, you're going to get arrested. If exigent circumstances, if you hear somebody screaming, help, 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 yes, the police don't have to say, oh my God, we have to get a warrant so we can save that person who's yelling, help, help, I'm being attacked by this maniac with a knife. No, they can come and arrest the maniac right away and break into the house if they have to save that person. Notice the police officers coming in at the very last scene of the very last episode of Breaking Bad. They heard machine gun fire. They didn't need to get a warrant because that's what's called exigent or emergency circumstances. Fifth through Eighth Amendments, rights of the accused. Fifth Amendment. Again, these are basic criminal defendants' rights. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land and naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put into jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Wow. That's a lot. So it also includes some other things besides just criminal rights, but let's get started with the criminal rights. Presentment or indictment of a grand jury. That's an ancient British legal tradition adopted by almost all U.S. states. A jury of between 12 to 23 people has to find from evidence presented to them that there's probable cause the suspect committed the crime of which he or she is accused, and thus that they should be indicted or formally accused of the crime and have to stand trial for it. So the old joke is you can get a grand jury to indict a ham sandwich. So Have people versus ham sandwich. Ha ha ha. Anyway. Double jeopardy. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. Defendants generally can't be tried twice for the same crime. Some mistrials that don't give the prosecution an unfair advantage are exceptions. So if there's a natural disaster that makes people have to close down the courthouse the day of trial, even if it's an hour after trial started, no. Probably no problem with just declaring a mistrial and starting over because nothing really happened. But if it's something where, there might be something that's prejudicial, that's going to cause a problem for the defendant, yeah, you probably will not be able to. Lawyers have a lot of discussions over it, whether double jeopardy has attached in those situations. A lot of huge arguments in case law over it. I'm not going to discuss it here. Anyway, the idea is they're trying to prevent the government's use of the criminal justice system to harass unpopular people. Imagine being put on trial more than once for the same criminal act. You say, well, wait a minute, you already found me innocent, you can't try me again. If they didn't have this, then they say, oh, that's okay, we made a mistake the last time, we're going to try you again. And that would certainly be a way for politically powerful people to harass people who are less powerful than them that they don't like. Pleading the fifth, the right against self-incrimination. I'm sure anyone listening to this has heard, I refuse to answer the question on the grounds that my answer may tend to incriminate me. And like a smart butt in my American history class in high school, I did the same thing when we were having a quiz, like, what's the Fifth Amendment? I said, I refuse to answer the question, and my history teacher said, shut up, John. Anyway, nor shall be compelled in any criminal case to be a witness against himself. So you've seen this in the movies, and you might be asking, well, why can't you force someone to tell the truth? I mean, the fact that someone answered, my answer may tend to incriminate me, itself seems pretty incriminating to me. If you didn't do it, why don't you just explain what happened? Well, the idea is you want to prevent torture, including enhanced interrogation tactics such as waterboarding, beatings, etc. There have been cases, not just in Iraq, where, U.S. troops were waterboarding somebody who they thought had information. It's been in Mississippi in the 30s, I believe, there was a case where state troopers, whatever they called them, highway patrol, sheriff's deputies, doesn't really matter, law enforcement, beat these suspects with leather straps until, lo and behold, they confessed to the crime. Certainly wouldn't be because they wanted to stop being beaten with other straps. Of course it was. That's why we don't do that. Because even back in those days, they know that coerced, torture-induced confessions are not very reliable. You start beating me hard enough with a leather strap, I will tell you that I was the Zodiac Killer, which happened before I was born. Okay? Anyway. Note, this generally doesn't prevent the police from applying psychological pressure to a suspect, including lying to the suspect. You have two criminal defendants, separate them, and then tell each of them, hey, your buddy ratted you out. Your buddy says you did it all, and they weren't innocent. If the person is a little bit gullible, they'll say, that rotten jerk, he did it, I didn't do it. Fine, now you've just confessed that, now you've just ratted out your friend because they lied to you. So anyway. This can lead to false confessions. I mean, if you put enough psychological pressure on someone and deprive them of sleep, they may actually crack and, eventually believe, oh, maybe I did it. Okay, yeah. So, see this video from Steve Leto, which I'm going to link here. It's pretty good, and there's a movement to actually do away with some of these commonly used police tactics. Fifth Amendment, due process of law. What is the due process clause? Well, okay, it forbids a government taking, and it says, okay, nor be deprived of life, liberty, or property without due process of law. So then there are a couple kinds. Procedural due process, you have a notice and right to be heard, so that there actually is a procedure. And substantive due process, fair and reasonable laws. So if the law itself is unfair, it's probably a substantive due process violation. If the procedure is unfair, then it's probably a procedural due process violation. You can only protest this thing between 11:59 and 12:16, 11:59 p.m. and 12:16 a.m. every other Saturday night / Sunday morning, and you have to be naked and covered in freezing cold water. That would not really be procedural due process. Anyway, The rights, including those listed in the Bill of Rights, including property and life itself, can be taken away from convicts, but they do have to be convicted first through due process of law. These rights are not inalienable. They can be taken away if you're found guilty. As a punishment, they can take them away from you. All right. Fifth Amendment takings. Nor shall private property be taken for public use without just compensation. So the government can take private citizens' property for public use. For example, a lot of highways, when they're built, they actually need to build them through existing residential neighborhoods or commercial neighborhoods. So they can say, well, eminent domain, we get to take your property. We need it for the military base. We need it for the highway. But they're supposed to pay you a fair amount for doing it. So even if you don't want to sell, they can make you sell and just pay you the money. Of course, this leads to problems as well. What the government that wants to build this highway thinks is a fair price and what you think is a fair price might also be different, let alone your idea of like, no, this is my family's home. We've had this for generations and I don't want to sell it in the first place. This is the kind of thing that was done, for example, when BART was built and the Bay Area Rapid Transit Train was built through West Oakland. A lot of houses had to be taken down, etc. So that definitely changed the neighborhood. So here's a little joke. A king, I didn't have any cash, so I used eminent domain. Ha ha ha. He said, oh, I have to use eminent domain on your food. It's a little inaccurate in that they would actually have to pay you for the food eventually. But anyway. This land is my land, fight bogus blights, stop the abuse, my home, not yours. It has been used in some cities, neighborhoods that, oh, this neighborhood is blighted. Well, we have an urban renewal initiative, so we're going to tear down these blighted houses and build new housing developments that have non-blighted houses that are all shiny and new. Except then the definition of blight was expanded to, oh, well, it's a single-family home, but it doesn't have a garage for cars in it, so therefore it's blighted. So that can be abused. Anyway, eminent domain is the right of the property to take your property with proper compensation. So that's in the Fifth Amendment. Sixth Amendment. The text of the Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and informed of the nature and cause of the accusation, to be confronted with witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have assistance of counsel for his defense. Now, that's a nice little package of things that help people who are being prosecuted by the government. So, the right to a speedy and public trial. Well, here we have Saul Goodman and Santa Claus and Miracle on 34th Street. So, the right to a speedy trial is the product of previous history. Officials had used criminal proceedings that dragged on forever or simply didn't start for a long time in order to keep political opponents imprisoned effectively indefinitely. Gee, you know what? We don't have any judges available, so we'll just have to keep you in jail pending trial, but we think we can get you a trial maybe 5 years from now. Okay, you've just given that person a 5-year jail sentence without actually finding that person guilty of anything. Today, it's actually often to a defendant's advantage to, in quotes, waive time. They might say, well, the more delay there is, the more likely it is that a witness forgets things, or blah, blah, blah. Hey, it's just if we do a favor for the prosecutor might be more amenable to a bargain, etc. Public trial. So secret trials encourage political abuse of the courts. Courts that know no one's watching can feel much freer to ignore the rights of the accused. Like this example of Miracle on 34th Street. If you never saw that movie, the idea is this guy was Santa Claus, and there was a big trial to determine whether Santa Claus existed, and this guy's Santa Claus, and there's a huge outpouring of public support. So this is photoshopped, obviously. We can see a little clip from Better Call Saul, where a very similar letter-writing campaign occurs to help out Saul's friend and client.
I have one question for you, Miss Erickson. Are you prosecuting Santa Claus?
Your Honor?
Because it looks like Miracle on 34th Street in here. Look at this. This is just today's batch. Huh? All addressed to me, all from some backwater in Louisiana. Look at, get your hands off our hero, they say. What, like I'm sending him to the electric chair?
So what does that mean? Is public outrage can affect the outcome of trials even when it shouldn't, but a public trial is much better for the defendant than a non-public trial where the judge doesn't have to feel bad, the jury doesn't have to feel bad, say, yeah, well, we really messed this guy up, but oh well, it's not like anybody knows. And the opposite of that, of course, is the old Berkeley protest cry. The whole world is watching! The whole world is watching! All right. So, the Sixth Amendment, impartial jury. So we have an impartial jury of the state and district where the crime shall have been committed, which district shall have previously been ascertained by law. So this solves a jurisdictional question, means what court do you hear it in? So that prevents the prosecution from, in quotes, forum shopping for favorable judges and juries. So if you have laws in advance that determine, okay, if this kind of crime happens between states, well, here's the way that we determine what state the trial should occur in. So let's say somebody's ordering illegal drugs through the internet. Well, if there's a law that says it has to be held in the home court of the person who ordered it through the internet, not where the seller is located, fine. Then that's going to establish it, so they can't say, oh, well, wait a minute, the person who ordered it is in New York, but California, where the person who shipped it out lives, is actually a much stricter jurisdiction on such and such, the dealing of this kind of drug or the selling of this kind of contraband. So, great, let's try it in California then. You'd say, the law says that if this thing allegedly happened, it has to be tried in New York, or vice versa. So anyway, the defendant may still have a problem if she, he, it, non-binary pronoun, whatever, allegedly committed the crime in multiple states or districts. It also doesn't stop the silver platter doctrine. So silver platter doctrine is the state can hand the case over to federal prosecutors if, oh, well, we have a problem if we try this in California, let's say Santa Clara County, but hey, if we give it to the federal prosecutors who cover the Northern District of California, oh, okay. Well, under federal rules and federal procedure, they can do a lot of things that we can't to put this guy behind bars, so all right. So the state can hand case over to federal prosecutors or vice versa to get an advantage. Individual judge shopping for trials also exists. If we know, okay, we want to get Judge Tough on Crime, not Judge Bleeding Heart for this. Also, they do that a lot. You've probably seen it on cop shows and movies for Fourth Amendment purposes. You know, the judge who's going to be a soft touch as far as making the police prove anything before getting a warrant for Fourth Amendment purposes, etc. So anyway, again, this isn't legal advice, but it's really important that these things be fixed in advance so they can't be played with as much when people in the prosecutor's office decide, hey, we want to prosecute John for this crime. Okay, well, where can we prosecute him? I know, let's prosecute him in this really, really tough on crime district where he's never been, but this package of stuff that he ordered went through, so, there we go. So we're going to have him tried in Arizona or something like that. Anyway, so that's important. And an impartial jury, of course, is important because you don't want the jury to already be prejudiced against or in favor of the criminal defendant. Anyway, Sixth Amendment, the accusation and right to confront witnesses. So, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him. Obviously, we can't have a fair trial without having advance notice of the charges. Can you imagine being arrested and tried for? Well, what am I being arrested for? You know what you did. Okay, that might work with your parents, that might work with whoever you're dating. Doesn't work with criminal charges. Same applies to the confrontation of or by witnesses. It's completely unfair if the accused doesn't know who the witnesses are. So you can think the Star Chamber, and there's a link to the Star Chamber article on Wikipedia, and that's going to be in the description below, or if you can't cross-examine them. That is, the witnesses were available but didn't show up at trial. So if you have a written statement or declaration by this person who could be produced at trial, probably not going to fly because, among other things, say, well, I don't have the right to confront this witness if this witness isn't there. There are some other things that also cover that, but we don't need to talk about that here. To have compulsory process for obtaining witnesses in his favor. That's one way to make sure that witnesses are available. You can subpoena them so they legally have to be present at trial. Again, the idea is so you can confront them, you can have them tell their story, etc. Can't just be somebody saying, I don't want to get involved. Well, that's too bad. You are being subpoenaed and you have to show up. Star Chamber proceedings. In case you don't know what a Star Chamber is, the Star Chamber is defined as any action, trial, or hearing which so grossly violates standards of due process that the party appearing in these proceedings, hearing, or trial is denied a fair hearing. This term comes from a large room with a ceiling decorated with stars in which secret hearings of the Privy Council and judges met to determine punishment for disobedience of the proclamations of King Henry VIII of Great Britain. So these high-handed, unfair, and predetermined judgments which sent the accused to the Tower of London to be imprisoned or to the chopping block to have their head removed made Star Chamber synonymous with unfairness and illegality from the bench. So if you have what's supposed to be a court proceeding that is just unfair and really is itself illegal, that can be called Star Chamber justice. So in modern American history, the best example of Star Chamber proceedings was the conduct of the House Un-American Activities Committee. Sorry about this weird formatting. But anyway, the House Un-American Activities Committee used its subpoena power, this is a different way to spell it without the O, but it's the correct spelling, to intimidate citizens by asking them unconstitutional questions about their political beliefs and associations. So you might have seen Senator Joe McCarthy in the 50s. Are you now or have you ever been a member of the Communist Party? Okay, that was unconstitutional, but back in those days, the Red Scare let them get away with it. And these people could be charged with contempt of Congress for refusing to answer. And so many Hollywood types, etc., ended up being implicated and blacklisted because people named them as people who had been members of the Communist Party, so they couldn't work in Hollywood. Another example was the conduct of criminal proceedings against black defendants in some southern states from 1876 until the late 1960s. Another synonym for Star Chamber proceedings is kangaroo court. Anyway, that's what these amendments are supposed to prevent, is unfair trials, or at least ones that are so ridiculously unfair that anyone could look at it and say, yeah, this is not a real trial, this is a farce, this is a kangaroo court. The Sixth Amendment, assistance of counsel, and to have the assistance of counsel for his defense. This is where public defenders came from. Criminal defendants are entitled to free legal counsel if they can't afford it. So this right was extended to the states. Before that, it was only in federal courts. In the case of Gideon versus Wainwright, which was a case where somebody was found guilty of breaking into a pool room in Florida, pool like billiards, and basically was denied counsel after it requested it. And it ended up going all the way to the Supreme Court, ended up in this book and movie, Gideon's Trumpet. I saw the movie when I was a little kid. It's a good movie. Basically, it shows that people who are denied counsel are often just denied any kind of substantive due process, because if you're a novice at doing court procedure, any prosecutor is going to be able to just knock it out of the park against you. They're going to say, yeah. It's like a little kid trying to play basketball against Shaquille O'Neal. Oh, really? Shaq managed to dunk on a 6-year-old kid? Wow, that's amazing. But anyway, so Gideon got his counsel, and in the movie they showed that Gideon, when he was represented by counsel, had a completely different outcome, on the retrial, as his attorney made the witness for the prosecution look really stupid and made it look like the witness probably did it. Anyway, this right also gives rise to a last-ditch appellate argument, that is ineffective assistance of counsel, the idea that defense counsel was so bad that the defendant was basically not represented in court by anyone because his purported defense counsel was so bad you might as well have not had an attorney. So usually this is brought up by death row inmates trying to avoid execution, but can be brought up by anybody who is facing some dire consequences or just wants to get out of jail and says, you know what, my defense counsel did such a bad job that I should be given a new trial. That results in some pretty bad consequences for the attorney if the attorney is actually found to have provided ineffective assistance of counsel because, you have a duty to provide competent and zealous assistance if you are an attorney. Anyway, let's move on. Seventh Amendment, jury trials. The Seventh Amendment reads as follows. In suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law. So basically, civil claims can be tried by a jury or must be tried by a jury when it's over $20. Back in those days, $20 was a lot of money, so it made perfect sense that, no, this is enough money that you should have to have a jury unless the parties waive it. And, the other issues that are under $20, etc., or if they're waived by the parties, they can be heard by a judge alone. So it only governs federal civil courts and doesn't apply to civil courts set up by the states. So federal district court, this applies. A state court, like Superior Court in California, doesn't apply. At least it doesn't apply when the court is hearing only disputes of state law. So you could have a situation where a state court is hearing a federal issue because nobody wants to have it in federal court, something like that. I don't know. Don't have a valid bar license, but anyway. So Seventh Amendment, more than $20, you can have a jury in a civil suit. I'm sure that's probably been changed by some rule. I don't think it's literally $20 in the year 2021. But anyway. Bail bonds. Okay, the Eighth Amendment. Cruel and unusual punishment, excessive fines, and bail. So the Eighth Amendment, wow, it's really just one sentence. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. You've probably heard of cruel and unusual punishment. Anyway, according to Wikipedia, we'll have a link in the description, the excessive bail clause of the Eighth Amendment to the United States Constitution prohibits excessive bail set in pretrial detention. So the idea you're accused of a misdemeanor, but they decide, no, you were accused of shoplifting, but we're going to set your bail at $10,000. Probably not realistic. The clause was drafted in response to the perceived excessiveness of bail in England. Excessive bail was also prohibited by the English Bill of Rights. If a judge posts excessive bail, the defendant's lawyer may make a motion in court to lower the bail or appeal directly to a higher court. So if you look at that article, it talks about sheriffs and things like that. They like to set excessively high bails because, hey, if you reneged on it, if you skipped bail, if you forfeited the bail, then that meant money for them, didn't it? So courts can deny bail if they believe defendants pose a threat to community if set free. Again, lots of TV shows, movies, etc. show that, the defendant constitutes a flight risk, so I cannot issue bail here, For a while, capital punishment itself, that is the death penalty, was deemed cruel and unusual and prohibited by a ruling of the U.S. Supreme Court. So cruel and unusual punishments other than the death penalty, at least during that time, it's back in effect now. You can think torture, okay? Generally, torture is not going to be something that any U.S. court will sign off on. Ninth and 10th Amendments, limits on federal power. The last two Bill of Rights amendments spell out the limits on the rights of the federal government. The Ninth Amendment prohibits any additional rights not mentioned in the Bill of Rights. It reads as follows. The Ninth Amendment, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So the idea here is that any right not mentioned in the Constitution is not necessarily meant to be denied to the people. That is, you can't say, it's not in the Constitution, so you don't get it, people. That's not true. So this is trying to avoid the application of expressio unius ex exclusio alterius. If I butchered the pronunciation, I'm sorry. That basically means that naming one thing means other things are excluded. So if I say, For breakfast, you can have cereal, bacon, or eggs. And then you say, well, actually, I like pancakes. I'll say, well, I didn't list those, so no, you can't have that. That would be an application of expressio unius, ex exclusio alterius. But if I said, I might say, well, okay, would you like bacon, eggs, or cereal, or something else? And you'll say, oh, well, I would like some watermelon or something. I don't know. Then I'll say, oh, okay, yeah, I happen to have some of that. I'll get you some. Example, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. So notice it talks about persons, houses, papers, and effects. That doesn't mean the police have the right to search people's cars and boats, since cars and boats, at least those that aren't used as homes, aren't mentioned in the Fourth Amendment. They might qualify as personal effects, but cars hadn't been invented yet. And, they say, well, they had horses and buggies and wagons, so if they meant buggies and wagons shouldn't be searched, they would have put that on there. Ha, ha, ha. Well, anyway, they can say, no, that's not the way that this is supposed to be applied, is people can have extra rights that aren't in the Constitution. And let's move on. All right, the 10th Amendment reads as follows. The powers not delegated to the United States by the Constitution, nor prohibited to it by the states, are reserved to the states respectively or to the people. So this is another rule of construction. I don't mean building, a building. We're not putting up a skyscraper. But construction also means how do you interpret things that are in laws. So it lets us know that any right the federal government isn't explicitly granted or denied should be assumed to be something that states can use. They can be state rights. If the states don't do anything with them, then they can be rights that are reserved for the people in general. This maximizes state and individual rights, or at the very least, it gives them much more rights than a system that would assume the opposite, that, it's not denied the federal government, so that means it belongs to the federal government, so that means you, state and general population, no, you got to ask the feds for that right, anything. That would be the exact opposite, where, they could say that anything that isn't specifically reserved to the states or the people, oh no, that belongs to the federal government. That would have made the federal government way too popular. It would have made the Anti-Federalist heads explode, because that's exactly what they were afraid of. So, 10th Amendment, the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. Voting rights. Voting rights are not in the Bill of Rights. You think they should be, but they're not. The federal government left it to the states to formulate their own voting laws. Again, anti-federalists, the states might have said, you know what, we're good with making our own voting rights. We're not comfortable leaving that to you. So, not until Reconstruction after the Civil War was voting seen as a fundamental constitutional right that needed constitutional protection. So you can see the 15th Amendment from 1870, which removed racial restrictions on voting, the 19th Amendment from 1920, which removed gender restrictions, it gave women the right to vote, and 26th Amendment 1971, which lowered the voting age to 18. All right, contact me. If you like this video, if you have some questions, if you'd like to hire me for tutoring, hey, you can go to Facebook, you can go to Instagram. Here's my phone number. This is my cell phone. You can even text me, 415-623-4251. Email, you can john@johnlenabal.com. You can go to my website, www.johnlenabal.com or johnlenabal.tutoring.com. It's going to take you to the same website. Testpreparation.locals.com. I always put these things up, uncut, uncensored. There's a 30-minute length, so I may have to limit it. If this is over 30 minutes, I may have to cut the thing in half. Other than that, that's completely uncut, uncensored. And lbry.tv, I'm at John Lenabal Tutoring. Again, that's another mirror site that you can look at. And that has a lot less, I don't think it has any ads, but certainly a lot less ads than certain other platforms. And if you want to reach me by snail mail, John Lenabal Tutoring, 1859 Powell Street, number 109, San Francisco, California, 94133. Note, this is not a substitute for your classes, text, etc. This video is based on the Barron's AP United States History Review Book, 4th edition, and any other sources listed in the video description, and my general knowledge of U.S. history and anything else that might apply. While this should help you on your AP U.S. History exam, I can't be responsible for what your teacher thinks is important and asks you about in or on his or her own tests, homework, etc. Please read your class text and pay attention to what your teacher says in class, and you'll do well in the class. All right, hope you have a good one.